court orders. Now I'm talking about a court order and a court judgment. I'm talking about a court record. Whatever I've been reading to you is a court record, which you should attach for people to see that we must obey court orders. If you don't agree with the court order,
you go back to court.
You don't fight it with the implementing agency. You don't fight it with the commissioner. Yes, a court order can only be stopped for being implemented if it is
by using another court order.
By using another court order, either it's set aside by court or it is stayed by court. Stay of execution.
Yes.
Yes. And the judgment, the judge has said that this court order has never been set aside.
The applicants, having failed to honor their part of the bargain, cannot insist on having the suit land as well. The applicants want to benefit from the compromise which they too have not honored.
In other words,
they are definitely.
In other words, the court is saying that the 750 million shillings, which they are basing upon, was non-existent. That's what the judge is saying. Yes.
But then the judge is also saying, I think, they want to benefit from both sides.
From
they
both
want to get the other 50 million, 750 million,
saying they want,
and at the same time,
he's saying that they have not honored
they
it.
too have not honored.
They are coming to court with unclean hands, and this cannot be sanctioned by courts of law.
Yes. He who comes to court must come with clean hands.
Yes.
In other words, court is saying, you agreed on the 750 million shillings.
Yes.
Now,
which you never...
of course, they had not yet got it.
Yes.
But now you are coming back to claim part of the what? Interest on the land. Yet you agreed on the 750 million,
which you never
that
paid.
When you are paid, you will have for
that when you pay,
all your interests.
That when you pay, when they pay,
yes,
then they would have settled the court order. The court order, yes. And the court has found that they never paid.
Andrew Lumba, my name is Andrew Lumba Katusale. This is the Spy Uganda Detective UG. I'm in the office of the Land Registry Commissioner, Commissioner Mugaino, who is a lawyer. I'm very sure you're a lawyer. Mr. Mugaino, if you could just in a word greet our viewers here.
Yes, hello viewers, I'm happy to see you. Thank you.
Mr. Mugaino, as you're not happy, what's the problem?
No.
Is that
it's office
is
hours.
That your way of life?
It's office hours, yeah.
Office hours?
Yes.
Hey. Now, I've read some news on social media that Mugaino, you are working against the courts. Court is telling you to do A, you are doing B. Specifically, on a case that you are holding in your hands. That court ordered you A and you did B.
First of all, I'm going to refer you to a judgment. And this judgment is by Lady Justice Flavia Nasona. It's dated 21st day of November 2025 this year.
This is November?
Yes.
Today is 28th?
Yes.
So now, the ruling is 21st?
Yes.
Last week?
Yes. This judgment summarizes all the issues that have been around when this matter started. Because this matter started when I was not an employee of Ministry of Lands. I'm not even here. The other commissioners handled it. I went up to the Supreme Court. Sarah Kwata handled it. Nyombi handled it. 2018, there were other court orders done by Justice Nkonge, court orders done by Justice Emma. So all these were done, but this judgment has looked at all this and summarized.
All those have been summarized into
and
one
in this judgment, those people, the petitioners, they reported the petition court that I was in contempt of court.
That's what I've also read.
Yes, it says that the respondents, that's Miriam Kutesa and Commissioner on Registration, be held in contempt of court orders and be committed to a civil prison. That's what they were reporting court to do, to give us an order. And this is what court held. I'm going to give you a copy of this judgment. I'm going to read the judgment itself. Court notes that, under paragraph E, I have noted that when considering the same matter, the Supreme Court under Supreme Court application 20 of 2014, the Supreme Court made a pertinent finding which cannot be organized by this court. The said finding was to the effect that High Court Civil Suit number 95 of 209, which was in favor of Miriam Kutesa, was actually fully executed way back in 2010 under instrument number 479500, by which the suit land was registered in the names of first respondent as administrator to the estate of Musa Muganzi Kalanzi as ordered by court. Now in 2010 and 2014, I was not here in the Ministry of Lands, but the court noticed that this was executed then. And then it goes further on to say, the Supreme Court further found that all the other subsequent efforts by the respondents to change the status quo using consent orders were futile. The findings of the Supreme Court are binding on the High Court, and I cannot depart from them. Then on my part, the judge says in paragraph F, I also note that High Court Civil Misdemeanors Application number 1863 of 2017, the second respondent, who's the commissioner,
Which is you.
yes, was ordered by court to implement the orders issued under High Court Civil Suit number 95 of 2009, or else he would be held in contempt and he accordingly, that's the commissioner, complied. The said court order has neither been reviewed or set aside. This is in the judgment. I'm reading the judgment.
That you,
Yes.
if you had not
Complied,
with the court, you
I would have been
held-
in contempt.
Yes.
And he said
Now
that
you have complied.
I have complied.
So now they are saying again you are the one in wrong, yet you have complied.
I have complied. This is the judgment of these are words of a judge. The same High Court cannot now turn around and hold me in contempt for enforcing what court ordered me to do.
They are talking about you.
Yes. This will not only cause confusion, but will be total amount to abuse of court processes. For all reason, the application now by other people that I'm in contempt is dismissed with the costs.
Costs and costs are awarded to you.
They awarded, yes,
You
and Miriam Kutesa. And this is High Court Minister's Application number 1863 of 2025. 863, sorry, of 2025. So, because they are saying that I abused court orders, now I'm talking about a court order and a court judgment. I'm talking about a court record. Whatever I've been reading to you is a court record, which you should attach for people to see that we must obey court orders. If you don't agree with the court order,
You go back to court.
you don't fight it with the implementing agency. You don't fight it
You
with
go
the
back to
commissioner.
court.
Yes. A court order can only be stopped for being implemented if it is
By using another court order.
by using another court order, either it's set aside by court or it is stayed by court.
Stay of execution.
Stay of execution.
Yes.
Yes. And the judgment, the judge has said that this court order has never been set aside. And the moment Miriam Kutesa applied for execution, the commissioner, having been told by court that he would be arrested, complied with the contempt of court.
So, Mr. Baker, because this is part in my investigations, this is part of the case that clashed you with the former IGG. This very case. Am I wrong?
You are right.
This is the very case.
Yes.
So, what is the real problem? Because I can see you have followed the court processes. After last time they were accusing you for not following the court processes. There is a time when they were accusing you for not
Following
implementing what court had said. Then finally you implemented what court said. Again another section came and started accusing you of implementing what court had told you. So on both sides you have been wrong. There is a time when they were accusing you for not implementing court orders. When you implemented them, another section of people are accusing you for implementing a court. So what is the gist of the matter? Where is the problem coming from? I remember last time.
I think.
Last time I came and I attended stealthily the meeting between the two factions. And in that meeting which you chaired, there was General Kaindo Tafid. You chased the journalists from covering the conference in that, and I was part of those journalists. And I had wanted to get the gist of the matter. Because forgetting about what people speak on both sides, because everyone wants to win. But what is the gist of the matter? What are the facts? You as the commissioner, what are you saying?
I don't want to go into an interpretation of the facts, because this has been settled by court, and that's why all my statements I'm reading a court judgment, because you can have your own perspective, I can have my own perspective. You can have your own evidence, I can have my own evidence. But all this is brought to court, and court has made a ruling. So I will not give a personal perspective. I will read to you a court ruling that says the commissioner acted wisely by purging the contempt of court and by following a court order as had been guided by the Supreme Court and subsequent courts.
So you are being accused, you are being maligned on social media. What do you think? What's the way forward? You as a person.
You see,
because you have implemented what
you see, of course, it is important for members of the public to know what the realities are, and also as a journalist, you owe a duty of responsibility to the public, not to misreport information that you have not investigated, or not to misreport information on bias, or not to change narratives, not to change narratives of court in misinformation, because this is a court record is a public record, and all these issues have been settled by court. Yes, and there must be rule of law in this country, and we must respect institutions. And it is surprising that an online or a media house can make such a story without seeking an interview from myself.
That's why I've looked for you.
Because
you know what I've gone through to get you.
Yes, because
because they want to know the truth.
Because I would have given this clarification for that media house to know, to report exactly what the realities are. Yes, and I'm giving you a copy of this judgment.
Yeah, have a look. There's some, I'm interested in the last pages normally. Let me just read it briefly here. The applicants have failed to rebut the aforementioned averment. What is the averment? Let me begin with the averment. The first respondent didn't deny having executed the said compromise, even though she alleged that it was null and void. No, I don't begin from the middle. I want to read.
You see, you cannot read all this on TV. I will just take you to
decision.
These are submissions. I will just take you to the rulings, because the rulings are very clear. This is the number D.
Let me read it, because they may think you are reading from your head. Number D. Suffice to note that the compromise was made way back in 2016, which is close to 9 years ago. You said you were not around at this time. The applicants have not given clear reasons as to why they have not met their part of the bargain. A clear scrutiny of the compromise shows that it was intended to be a give and take arrangement, whereby the applicants were to pay 750 million to the first respondent in lieu of the suit land. The applicants, having failed to honor their part of the bargain, cannot insist on having the suit land as well. The applicants want to benefit from the compromise, which they too have not honored.
In other words,
they are definitely.
In other words, the court is saying that the 750 million shillings, which they are basing upon, was non-existent. That's what the judge is saying. Yes.
But then the judge is also saying, I think, they want to benefit from both sides.
From
they
both
want to get the other 50 million, 750 million,
saying they want,
and at the same time,
he's saying that they have not honored
they
it.
too have not honored.
They are coming to court with unclean hands, and this cannot be sanctioned by courts of law.
Yes. He who comes to court must come with clean hands.
Yes.
In other words, court is saying, You agreed on the 750 million shillings.
Yes.
Now,
Which you never.
of course, they had not yet got it.
Yes.
But now you are coming back to claim part of the what interest on the land. Yet you agreed on the 750 million.
Which you never
that
paid.
when you are paid, you will have for
That when you
all your
pay.
interests.
That when you pay. When they pay,
Yes.
then they would have settled the
They
court
would have
order.
settled
The court order,
yes.
and the court has found that they never paid, so they cannot based on it. You put this judgment, and people will appreciate it.
Notwithstanding the above, I have also noted that when considering this same matter in a civil case in SCMA number 20 of 2014, civil court. This is a civil court. The Supreme Court made a pertinent finding. That is 2014 before you came
Yes.
in office. I want the viewer to understand this. This matter was in court before you came, 2014. When did you come?
I came in 2021.
2021.
Yeah.
So this matter was 2014. The Supreme Court made a pertinent finding which cannot be ignored by this court. The said finding was to the effect that High Court Civil Suit number 95 of 2009, you can imagine there was 2009, was actually fully executed way back in 2010 under instrument number 479500, by which the suit land was registered in the names of the first respondent as administrator to estate of the late Musa Muganzi Kalanzi as ordered by court. The Supreme Court further found that all other subsequent efforts by the respondents, current applicants, to change the status quo using consent orders were futile. The findings of the Supreme Court are binding on this court, and I cannot depart from them. I also note that in High Court miscellaneous application number 1863 of 2017, the second respondent was ordered, that is you now.
Yes.
They are talking about you. They ordered you
Yes.
in 20. But this is not you, because this is 20.
Yeah, but the
2017.
office, yeah.
They ordered the office,
Yes.
the commissioner,
Yeah.
lands, 2017.
Yeah.
Was ordered by High Court to implement the orders issued under High Court Civil Suit number 95 of 2009, or else he would be held in contempt, and he accordingly complied. The said order. Now, which one was this? The commissioner 2017 who implemented?
No, I'm the one who implemented. You go ahead. You read the judgment.
The said order has neither been reviewed nor set aside by court. The same High Court cannot turn around and hold the second respondent in contempt for enforcing what he was ordered to do. That is you now.
Yes.
This would not only cause confusion, but would be tantamount to abuse of court process. For all the reasons advanced above, this application hereby fails and is dismissed with costs to the first respondent. The first respondent is Miriam.
Miriam, yes. Yeah.
Dated at Kampala, this 21st day of November 2025. Today is 28th of November.
Yes.
This ruling was 21st
Yes.
of November,
Yes.
last week.
Yes.
So, really, if you are writing about this case, you are basing on the history. You are accusing Mugaino. Have you read this as a journalist? This is the question that we should be asking ourselves. Have you read this? Because now this is the latest.
Yes.
And when there is this ruling, it covers all the past
Yes.
rulings.
Yes.
This is because now this is the status quo. So before you accuse Mugaino, have you read the ruling, you journalist? Mugaino, your last word. What could be your last short? What are you saying?
Of course, my last short is that, of course, we understand, I may understand when a party is not comfortable with a particular position of court, but the lawyers also should advise parties accordingly. Court matters are not settled in the media. Court matters are settled through court. Yes, and as an implementing agency, we are bound by court decisions. Yes.
Mugaino, this is personal.
Yeah.
This is personal.
Yeah.
You've been going through a fire. You are back in office. How is the office now?
No. I don't want to comment about it. We are working.
You can speak about
No, we
how
are
did you fail the
working.
office?
No, we are working. You came to office. We are working, and the work is going on normally.
My last one would be these titles. When are you giving these titles to the rightful owner? The titles.
They know the procedure. They are supposed to apply for them in writing, and then we will issue them.
You will issue them?
Yes, because the court order standing. Yes.
Kale, thank you very much.
You're welcome.
Thank you so much. And remember, live.